the Director of Regional Development for National Review Institute. National Review Institute is the journalistic think tank founded by William F. Buckley Jr. in 1991 to complement the mission of National Review magazine. NRI typically holds about 80 plus events across the country every year, and for obvious reasons, most of those are on hold right now. But we have successfully transitioned into the virtual world that we're in today. And as a Wisconsinite myself, I live in Oak Creek. Thrilled to be hosting today's virtual event with the Wisconsin Institute for Law and Liberty. Wisconsin Institute for Law and Liberty was founded in 1991 by President and General Counsel Rick Esenberg. It's a nonprofit, nonpartisan policy center based out of Milwaukee. Since its founding, Will has become one of the most frequent advocates before the Wisconsin Supreme Court. And Rick holds the distinction of having argued before that court more than any other private attorney in the state. Rick, is that still true, or has the record shifted hands?
I don't think so.
Okay, very good. In conversation with Rick today on the topic of reopening Wisconsin and the country, in fact, is Andy McCarthy. Andy's a former top federal prosecutor, contributing editor at National Review, frequent Fox News contributor, and commentator on political and legal affairs. He's a former chief assistant U.S. attorney in New York and has served as an advisor to the Deputy Secretary of Defense and has numerous New York Times bestsellers. For those that are on the call today, we do want this to be an interactive event. So you should see at the bottom of your screen a chat box feature, which is where we're going to take Q&A. So please don't be bashful to pepper Rick and Andy with questions throughout this conversation today. And we'd have reserved at least 20 minutes at the back end of the agenda for me to hop back in and facilitate those questions. So again, the chat feature at the bottom of your screen is where we want to post those questions. So the last thing before I hop off, I think originally we had talked, when we scheduled this event, thought we might talk about federal issues and then go down into Wisconsin. But with some of the recent developments at the Wisconsin Supreme Court, I thought I would ask Rick to start us off and give us an overview of some of the developments there and what you see next for Wisconsin.
Well, thank you, Chris. I think that what happened in Wisconsin is significant nationally, and I wanted to describe what the court did, place it in context, and then have a conversation with Andy about what the ramifications are nationally and what we've seen in other states. Wisconsin became the first state to move out of lockdown by litigation, by court order. But the decision in Wisconsin Legislature versus Palm was not the type of individual constitutional liberty claim that we would normally associate with litigation challenging stay-at-home orders. It was a decision which was concerned not with individual freedom, but with structural limits on the power of government. And to that extent, it illustrates how these structural limits, separation of powers, federalism, certain rules with respect to the ability of the administrative state to make law, are actually liberty-enhancing devices, as our founding fathers thought that they would be. Here's what happened in Wisconsin. The governor initially issued a stay-at-home order in mid-March. In doing so, he relied in part on his authority under Wisconsin Chapter 323 to declare a public health emergency. Once a public health emergency is declared, the governor has broad power to issue any order to protect any person or property. But though that authority is time limited, the public health emergency can only last for 60 days. It can be rescinded at any time by a joint resolution of the legislature. It can only be extended past the 60 days, can be extended for an additional 60, by a joint resolution of the legislature. So as we reached mid-April and the governor contemplated and decided that he wanted to extend the stay-at-home order past the expiration of the public health emergency, which would have been May 12th, of this year, he had a choice to make. He could go to the legislature and he could seek authorization to continue the public health emergency, which would have required compromise, or not. He chose or not. What he decided to do was look to another section of the statute called Chapter 252, which imposes facially broad authority on the Department of Health Services to take steps to control infectious disease, and argued that this was a backdoor through which he could instruct one of his cabinet officers, the acting secretary of the Department of Health Services, to essentially extend his stay-at-home order. And that's what happened. This created a bit of an anomaly. It rendered the time limits on the governor's powers under a public health emergency essentially meaningless, and removed the question of legislative oversight over the declaration of one of these emergencies and the exercise of these extraordinary powers, essentially, meaningless. There's no possibility to do this. The legislature could not become involved, not only for that initial 60 days to respond to an emergency, but indefinitely. So the upshot was the governor of the state of Wisconsin is contending that one executive official has the power to lock down the state indefinitely as long as it can be claimed to be necessary for the control of infectious disease. We put out a paper within a couple of days suggesting that there were all manner of legal and potentially constitutional problems with this. The legislature came to the same conclusion, and it filed a lawsuit in late April. The legislature did not argue that the extension of the stay-at-home order was unconstitutional. What they said was that to interpret the law in this broad manner, in a way that gave that much authority to a single executive officer, would raise constitutional questions. And under the doctrine of constitutional doubt, that is the idea that we should construe statutes to avoid constitutional problems, it argued that the statute should be construed narrowly to, one, require that the Department of Health Services proceed by rulemaking, right? That the DHS secretary could not simply issue an order, a decree locking down the state, but would have to attempt to promulgate a rule. And when an administrative agency promulgates a rule, there has to be public notice, there has to be an opportunity for public comment. There is in Wisconsin then an opportunity, once the rule is promulgated, for legislative oversight. The rule can be suspended by a joint committee of the legislature for a particular period of time. And that was the first argument that the legislature made. The second argument that the legislature made was that under Wisconsin law, you cannot make a rule based upon a broad grant of authority to administrative agency. There has to be explicit authority for rulemaking within the statute somewhere, other than simply saying the Department of Health Services does stuff to preserve the health of the state. And it argued that the broad language of Chapter 252 regarding controlling infectious disease needed to be narrowly interpreted to apply only to things sort of traditionally done to control infectious disease, that it couldn't be used to order people who were not infected or not reasonably suspected of being infected to stay at home. It couldn't ban individuals from traveling. It couldn't close what were deemed to be non-essential businesses. Those were the two arguments that the legislature, for the most part, advanced. We developed the constitutional issue. We filed an amicus brief on behalf of some small business organizations and small businesses that said, look, if you do interpret Chapter 252 this broadly, it is, we think, an unconstitutional delegation of legislative authority to an executive officer. That's a very, very difficult claim to make. They don't generally succeed. But there is some law in the state of Wisconsin that suggests that there needs to be procedural safeguards governing delegations of legislative authority. And we think it's still necessary and, in fact, critical for the legislature to provide substantive guidelines and direction in order to avoid a separation of powers issue, right? And this is an issue that the Supreme Court has been wrestling with lately, suggesting that they are going to take a closer look at delegations of legislative authority to administrative agencies. And we were essentially attempting to argue that this was an appropriate case of the same type of reexamination to happen in Wisconsin. A majority of the court agreed that with the legislature. It agreed that the secretary needed to proceed by rulemaking. It agreed that the existing stay-at-home order was overly broad, and but it declined the legislature's invitation to stay the effective date of its order for a period of time in order to allow the secretary then to promulgate rulemaking. And so essentially the court ruled and Wisconsin's stay-at-home order was ineffective. Since that time, the matter has proceeded in a way which I frankly would not have predicted. It would have been my expectation that the Republican Legislative Caucus would have its own transitional plan to bridge the gap between a stay-at-home order and a return to normal. They have not done that. I would have also expected that either in the face of such a plan or in the absence of such a plan, that the governor would then proceed to promulgate the rule that the court said must be promulgated in order to have a stay-at-home order. The governor initially did that. You do that in Wisconsin by issuing a scope statement. That happened. It was published yesterday morning, but by noon, the governor withdrew the scope statement, essentially saying, I don't think the Republicans would let it go into effect anyway, so I'm not going to waste any time on it. So that's the situation where we are now. The situation here is that there is no statewide stay-at-home regime. There are some localities who are attempting to have local, essentially by county or city orders. I think some of them are of dubious legality, some of them are not. But I thought having set the stage by explaining what has happened here in Wisconsin, that it would be useful to bring in Andy and have a conversation about what the US DOJ is doing, what's happening around the country. I know that Oregon, a lower court judge in Oregon issued not the same, but a similar order in which she held that the governor of Oregon, the stay-at-home order had expired because there was a time limit on it and he had not gone back to the legislature. But you know, what's happening around the country with respect to these stay-at-home orders right now?
You know, Rick, thank you very much. When we first started to discuss this, it seemed like one of the major issues that was being overlooked, because everybody looks to Washington, particularly at the beginning of a crisis, is the fact that in our Federalist system, most of the governing, and I think your remarks show this to a fairly well, most of the governing is actually intended to go on at the state level. So what the federal government, depending on how assertive it wants to be, can do is mainly at the sort of macro level, dealing with big Bill of Rights issues. But where the rubber meets the road for most of this really is at the state level. I mean, I found myself, while you were running through that description, you mentioned a number of times what the Constitution required. And of course, I'm thinking, and then I'm realizing you're talking about the Wisconsin Constitution, right? Which, you know, we never even consider, but I think what we're starting to see, again, we're in the places where the rubber meets the road, is that state constitutions, which virtually have no bearing whatsoever on our national discussion about our rights, are actually critically important. And that is obviously how it's playing out here. One of the big issues that we were dealing with at the very beginning here, and I want to talk about this a little bit because it goes to something I think I turned out to be wrong about, and that is the distinction between where federal authority is and where state authority is. The president at the beginning talked about his own ability to quarantine, including to quarantine. I think at one point he was talking about a network of states in the Northeast. And specifically, I think it was New York, New Jersey, and Connecticut. May have been more than that. But he seemed to assume that he could do that on his own power. And the big issue that was being discussed at the beginning was, well, certainly the federal government has a critical, compelling interest in preventing the spread of infectious disease. And Supreme Court jurisprudence says that when the federal government has a compelling interest, your rights still exist. They can infringe on your rights, but they have to do so by the least restrictive means. So the issue was, does the president actually have the authority to take an action that can quarantine people inside the states? And it seemed to be like completely out of Washington's way of thinking, that actually the states would be the ones who would get to decide whether people could be quarantined within the states. And it would be an interesting issue how much interplay there would be between what your federal constitutional right was and what the state's power was under the state constitution. But the thought was that there wasn't much that the federal government would have to say about what whether it was a municipal executive or the governor could do in the way of that kind of regulation. The federal government could have a lot to say about interstate commerce, and certainly the federal government has a lot to say about border security. But really, where this is playing out is more of a matter of state law, I think. The two differences, and I think this is why the Wisconsin situation is so important. One is what we're seeing at the federal level with the Trump administration is a federal government that seems disposed to protect individual liberty, as opposed to what's going on in a lot of the states, certainly in your state, where you have the executive branch kind of flexing its muscles and asserting its ability to infringe on people's liberties and limit them. I think at least where religious liberty is concerned, which is where the Justice Department has most asserted itself so far, they have been able to make the case that if the state governments infringe on religious liberty, they cannot discriminate against religious liberty versus what they would do in the context of commercial relations. So to be more concrete about it, you can't prevent people from having drive-in religious services, but at the same time allow restaurants to have drive-in food service. They have to be consistent in how they enforce the restrictions on religious liberty vis-a-vis how they do it with everything else. And I think the fact that the Justice Department has made it clear that it's willing to jump in those cases and has suggested that there may be other cases it's willing to jump into as well, that's having an interorum effect on the states, because as we've seen again and again, we saw it in the Obama administration in connection with civil rights litigation. The states do not want to litigate with the Justice Department if they can avoid it. The Justice Department has a $30 billion budget, and if you're talking about most municipalities in the United States, they don't want to get into that kind of a contest. Um,
Just as an aside, one of the things that I learned as a very young lawyer is that nobody wants to have a V between their name and the name of their country. And
yes.
so it's very, if the federal government coming down on you is very, very intimidating. I'm sorry,
Amen.
go ahead.
And let me just get to the thing that I think I was wrong about, which I think your experience speaks to as well. And that is when this first began, I made the point a number of times that in the history of the United States, when you're dealing with catastrophic events, particularly wartime, terrorist attacks, but catastrophic events that either portend or have the reality of instantaneous mass death. The tendency in our country has been for the legislatures and the courts to give the executive a wide berth to deal with the emergency. And then only later, after the crisis has passed, does litigation happen and legislation happen in a way that cuts back on what the executive did, which is cold comfort to the people whose rights are infringed in the first instance, but at least creates norms for the future. And I thought this would be that kind of a situation. But I think what we're seeing is because an infectious disease is kind of a gradual, slow motion event, not something that portends instantaneous mass death, but rather something that we may be dealing with as a simmering crisis for months and months. However hesitant the courts in particular may have been at the very beginning when we were still trying to get our arms around this, I think as time goes by, you're seeing courts willing to assert themselves right now in the middle of a crisis, which is not something that you ordinarily would see in wartime or with even a catastrophic natural event. And the pace of litigation, I think, is picking up. And I'll just leave it for questions with saying, I think what Rick's experience and Wisconsin's experience demonstrates to us is that there's a national conversation going on, but probably the most important thing goes back to something the framers recognized, which is that most governance that is of importance to the way people actually live their lives is the governance that happens at the state and municipal level, not the federal level.
Thank you, gentlemen. This is a great primer on the federal and state response. And we have a number of very interesting questions coming in. So I may ask them of both of you or direct them to one or the other based on kind of what you've already laid out. First, Isaiah asks, if and when a vaccine is developed for COVID, what are our liberties if such a vaccine becomes mandatory? And I'll open this up to either of you to address.
This is the Alan Dershowitz. Yes, somebody asked me yesterday. Happily, I was in the middle of four other things, so I didn't have time to get into it. But they said, Professor Dershowitz wants to strap everyone down and force them to be inoculated. And if they won't, he's ready to throw them in jail. Or actually, he doesn't have to throw them in jail because he's just going to force them to be inoculated. I think it's a very interesting question. It sounds it sounds a little extreme at the beginning, except if you've worked in the criminal justice system, as I have, and you've had to deal with people who go on, food strikes and medical strikes when they have medical conditions, there are circumstances under which the state asserts the right to inject you, whether you want to be injected or not. I still think that I'm not ready to sign on to Professor Dershowitz's idea that that the state can force you to get a vaccine. I would be very surprised if that turns out to be the law.
Yeah, I think that would be a heavy lift, particularly in light of the fact that I think in most scenarios that the percentage of the population that is going to refuse the vaccine is going to be relatively small. And herd immunity does not require complete immunity. And so I think that if you got into any type of rigorous balancing test in terms of some right to be, have a freedom of bodily integrity and not having the state impose on your person in that way. I think it would be a tough thing for the state under most foreseeable circumstances to say that you don't have a constitutional right to say no.
I would just add one other thing on that. I do think it still comes down to, even with this extreme example, least restrictive alternatives. And if a person would not be vaccinated under certain circumstances where you had a really dangerous infectious disease, there are lesser measures that the state can take to isolate you than actually violating your person. And that's probably, I think that's the way that a court would look at it, but it'd be a very interesting question.
Leslie asks, our local mayor, and this is in the city of Racine, just south of here in Milwaukee, just south of Milwaukee, is putting before their council a resolution to extend the mayor's emergency order through July. How can he do that after the ruling of the Supreme Court?
Well, the court's order did not address the power of local officials. It addressed the power of state officials under 252.02, but there's a 252.03 that talks about the power of local officials to take steps to control infectious disease. We just put out an analysis on this yesterday, but I think that the bottom line here is that even though the court's decision did not address that power directly, it did construe broad language about prohibiting public gatherings and taking steps necessary to control infectious disease that applies to the state, and construed it in a narrow way in which the state cannot sort of proceed under this sort of lockdown theory that presumes that all human contact is dangerous, therefore all human contact must be minimized, but rather has to do things that are more directly targeted at controlling the spread of the disease, perhaps concentrating on persons who are infected or there's some reason to believe are infected, can't close non-essential businesses, can't order people to stay at home, limited capacity to ban private gatherings. It seems likely that the court would construe similar language in this 252.03, which grants authority to local units of government in the same way. And so that to the extent that a local order attempts to basically replicate the statewide stay-at-home order, it probably goes too far. Now, where that line is between how far local officials can go and then what goes too far because it runs afoul of the same limiting construction that the court adopted in Palm is unclear. We don't know that, and we won't know it until the court tells us.
Andy, question for you. Can you explain the Stafford Act and whether it was appropriate to have been invoked during this crisis? And if not, and you hit on this a little bit earlier, what other tools does the federal government have at its disposal?
Yeah, it's interesting, Chris. There's an array of powers that the federal government has that actually arose out of the time between the Second World War and the Korean War. At the end of the Second World War, we ramped down as far as the war effort was concerned and war powers were concerned. And then the Korean War broke out, and there was concern at the time that happened between the Korean War, the real beginning of the twilight struggle with the Soviet Union, the fact that that Mao won the civil war in China, there was a sudden concern in the United States that the federal government was not prepared for these kinds of emergencies, natural or the potential emergencies, natural and otherwise. So the government enacted some somewhat questionable provisions that allowed it to commandeer parts of private enterprise in order for the war effort to go forward. And much like the debate that we've had in the last number of years over the Foreign Intelligence Surveillance Act, FISA, a lot of these provisions came with sunsets, so that every few years they get evaluated again, and a decision would be made about whether we really needed them or not. And a lot of what was enacted in the Korean War era has actually been peeled back. So it's not as robust as it was when it was originally enacted. But the government does have powers to basically compel the states or compel private industry to ramp up productions of things that the government needs for purposes of responding to crises. It has the ability, and this is mainly what it does, to immunize businesses from any claims that they could of liability that they could have because they have to prioritize government orders and the like. What President Trump has done, and Rich Lowry actually has a piece about this on National Review today, in terms of FEMA's ramping up on PPE and masks and other stuff that the government has needed on this. What the Trump administration has basically done is use these provisions for saber rattling purposes rather than to invoke them and actually try to force the businesses to do the things the government has wanted. And that's been a pretty successful strategy. I think they've been able to do a lot without actually having to invoke these laws much.
All right, Rick, this might be a question for you. Judith asks or says, I read the entire Supreme Court decision, bless her heart. I thought Hagedorn's concurring dissent was well-reasoned and written, especially as to the second point on standing. What is your response that the legislature does not have standing to argue that its own statute is unconstitutional?
Well, so I think that Justice Hagedorn took a different approach. As I think I indicated in my opening remarks, the legislature did not claim that Chapter 252 was unconstitutional. We did that. We said that if you read it to concentrate this authority in the hands of one executive officer, that it would clearly be unconstitutional, but we were only an amicus party. And so I think that if you read the majority of opinion, their opinions are haunted by these constitutional concerns, right? They are very, very concerned about the implications of the constitutional implications of concentrating this type of authority in a single set of hands. And if you are concerned with that, it isn't much of an answer to say that the legislature gave its power away, because our separation of powers it doesn't exist for the benefit of the people who exercise the power. It exists for the benefit of the people. It is a liberty-enhancing device. It is a device to attempt to inject more prudence and input into governmental decision-making. And so when it comes to this constitutional concern, the legislature doesn't get to give away its power. It doesn't get to say, okay, we want to make a law about something, but we don't want to specify what that law requires, and so we're just going to empower an agency to do it for us. Right? That presents constitutional powers because the legislative authority is vested in the Senate and the Assembly in Wisconsin. It's vested in the legislature in every state that I know of, and the legislature cannot give that power away. Now, to be sure, over the past 80 years, the courts have not rigorously enforced that limitation. Right? The non-delegation doctrine basically had one good year in the U.S. Supreme Court, and although there are some justices that want to reinvigorate it now, that hasn't happened yet. In Wisconsin, non-delegation concerns have generally focused on procedural limitations, that you can delegate authority, but there has to be some type of procedural limit on, but they don't say you can delegate it, but it essentially says if you have an administrative agency doing something that constitutes the making of law, there has to be procedural limitations on it, and there were no procedural limitations here. Justice Hagedorn didn't really get into any of that because he said, well, the legislature hasn't raised that issue, and I don't really think the legislature could raise that issue because I don't see how it could challenge its whether or not a law it passed was constitutional. And so I'm essentially going to put all of that aside, and I'm not going to get into it. The majority, I think, took the view that they had to get into it, that they had to apply this statutory rule of construction called constitutional doubt, which says that if a construction of a statute, if an interpretation of a statute would create constitutional concerns, you should try to construe the statute to avoid it. And so it was, I think, the difference in approach that explains at least some of the distinction between what the majority did and what Justice Hagedorn did. I'm with the majority on that question.
Andy, I know a few weeks ago you wrote an article basically saying that the government bears the burden of proof on coronavirus restrictions. And Doug Hoffer asks a question with that, which I think maybe plays into that. His question is, how can local orders properly balance mass gathering bans with the freedom of assembly? So how is that balanced?
Well, yeah, what I was talking about, Chris, and it's a great question because it goes to the tension that we're seeing in every one of these issues. And what I wish I could say I came up with that one by myself, but I was just parroting what the Justice Department had said, because I thought Attorney General Barr's comment on this was particularly trenchant. It's so simple and straightforward, yet it's something that's not at the front of people's minds, and it should be. And that is, as we see governments react to crises, and we recognize that particularly the federal code is just strewn with these emergency provisions, some of which are decades old and have never been repealed or pared back in any way, that gives them an enormous amount of statutory authority to just act, which is always dangerous in this system. And the system is based on the ability of the different actors in the system to check each other and not concentrate all the power in one set of hands. So we have this problem all across the law, at least certainly federally. But what Attorney General Barr said was, it's not the job of the citizen to prove that his job is essential or to prove that his rights, his fundamental rights, are essential under the circumstances. It's the burden of government to establish that your fundamental rights or your job cannot be exercised or cannot be conducted safely other than under the restrictions that the government wants to impose. And the Justice Department's view on this, which I agree with, is that from the beginning of this pandemic crisis, it seems to me that the shoe has been on the wrong foot. We've sort of given a wide berth, as you would typically do, as I said before, to executives who have to react to a crisis. You would typically, at the beginning of the crisis, when you don't know yet how serious it is, they have to have a wide berth to deal with it. But once things settle down a little bit, we have to get back to the idea that the burden is on the government to establish that this has to happen, because there's no less restrictive way to allow the government to perform its basic function here to prevent the spread of infectious disease, while giving due indulgence to people's ability to work, people's ability to have economic liberty, and people's ability to have personal liberty, including free association and the like. From my own point of view, for what it's worth, I think these lockdown restrictions have been unreasonable. I don't know that they're supported by the best science in most instances, but it doesn't seem to me, it seems to me that in almost every situation where this has come up in a controversial way, that there have been lesser measures that these governments could have enacted or could have tried to implement that were less restrictive than, these sweeping bans. And I guess I would close on that, Chris, by saying what I think has been the big issue from the beginning, and in many ways transcends the legal niceties of all these questions. We could talk all day about, what compelling interest does the Supreme Court say governments have? What are your fundamental rights? What are the constitutional formulas and the jurisprudence? What does it have to say about when these things collide? But to me, this is more of a political legitimacy issue than it is a legal issue. And it continues to be true that if you combined all of the federal, state, and municipal police forces in the United States, they could not enforce, say, stay-at-home provisions or aggressive social distancing against 330 million people, which is to say, if you don't get buy-in from the public, and if you don't make the public, convince the public that it's in the public interest to cooperate in these efforts, you're putting police in an impossible position, and you're really, I think, threatening the rule of law, in the sense that if you put the police in a position where they have to enforce arbitrary restrictions, number one, they won't be able to, and number two, it will erode their authority to the point where they won't be able to do the things that we need the police actually to do.
And we've seen that in Wisconsin, and we've seen that across the country, where there have been public assemblies that were in blatant violation of stay-at-home orders, and law enforcement did precisely nothing, because it was impractical to round up a couple thousand people who were standing on the lawn of the state capitol.
Question for you both. As some states continue to extend the safer at home measures, is there a scenario where the federal courts may get involved?
Yeah, I think that the Justice Department has been hesitant to this point to get involved in anything other than religious liberty, which Barr kind of identified as a bright line. And I think those cases are easier for the Justice Department. Number one, because you can make a pretty compelling demonstration of discrimination, which is the big bright line for them. And I think secondly, and this is more Rick's side of the street than mine, but I think that the federal government's view is that, and this Justice Department's view, is that you have to allow the states a considerable amount of liberty to regulate, particularly, or freedom to regulate, particularly in commercial relations. So it's, this federal government, I don't know if you had a different administration, if it would be different, but this particular administration clearly does not want to get into litigation, or has been hesitant to get into litigation when it's about economic regulations as opposed to something like religious liberty.
Yeah, I think these federal claims are more likely to be claims of individual constitutional liberty. And when you do get into economic liberty claims, they become very, very difficult because they get rational basis review, which in most instances essentially means that if a government's rationale for a restriction does not violate the principles of formal logic or the laws of physics, it survives. With respect to fundamental rights claims, even when you have the right of free speech, the freedom of religion, you will inevitably get tossed into some type of balancing test of more or less rigor. You could have, strict scrutiny where the state has to show a compelling interest. They have to show that the restriction is necessarily tailored. And I think initially litigation organizations like mine would be pressed to do something, to file a lawsuit, came to the conclusion that it's too soon for that for the reasons that Andy explained. And the phrase that I kept using is, as soon as we start talking about the epidemiology, we've lost, because no judge is going to re-examine that, particularly in the early days of the crisis. I think that is changing now, in part because of the slow burn nature of this and the fact that in most areas of the country, maybe almost every area beyond New York, what has actually happened on the ground would not be anywhere near enough to justify the type of restrictions that have been imposed. People have been poking at these models. The models aren't very good. I don't think they could be expected to be very good given what little was known about the virus. And so I think you're going to see these cases begin to be filed. I think you're already seeing it. And there is a tendency to want to go to federal court. Sometimes it's better to go into state court. For example, in the religious liberty area, you can make this discrimination claim that Attorney General Barr is emphasizing. But when it comes to sort of a general burden on religious practice, although the court is currently re-examining this doctrine, basically a general law of neutral law of general applicability doesn't violate the free exercise clause. But in some states, like Wisconsin, that's not the case. If there's a substantial burden on religious liberty in Wisconsin, our court has held that under the Wisconsin Constitution's protection of free exercise, you have to apply strict scrutiny. And so you have, at least formally, a leg up, right? Because you have a more rigorous balancing test. But there is a sense, particularly in the early to intermediate stages of a crisis, that the distinctions between these balancing tests, strict scrutiny versus intermediate scrutiny versus rational basis scrutiny, probably don't matter as much as, I think Andy had it right, the sort of the political legitimacy and the situation on the ground and that affect courts as much as they affect anyone else.
Okay, we only have about 5 minutes left, so maybe two more questions. Brian Bell asks, many government agencies have suspended administrative rules due to COVID, showing that these rules may have been unnecessary in the first place. What can be done to prevent reinstating these unneeded administrative rules?
Well, on that, I think the conditions for that are going to probably vary from state to state. What has to be done in order to either suspend a rule or to repeal a rule is a matter of whatever law under which the rule was created. I know that sounds trite, but when the crisis passed, if we get back to a normal, it's going to be a normal that existed before the crisis, which means these rules would be in effect unless there was any way of repealing them under the system in which they were enacted in the first place.
As somebody that heads a think tank that focuses on its policy side and deregulation, I think it's a beautiful thing. If there's a silver lining in all of this, it's that, maybe we've figured out that you don't need 4,000 hours of training to do something that's relatively simple. And maybe we've learned that, it's really okay to let nurses and doctors who are licensed in Illinois come over here and practice in Wisconsin. And so there's still a great deal of power behind these regulations because they are generally designed to protect incumbents, and incumbents are going to want to be protected just as much after this is over as they did before. But now at least we have some experience where we suspended some of these rules and the sky actually didn't fall, right? The public was still okay. And so maybe we'll have more success in paring some of these things back.
Okay, this might be a quick one, but a few weeks ago, Senators Marsha Blackburn and Martha McSally proposed a bill that would allow Americans harmed by the coronavirus, if they have died from it, to sue China or other countries for damages. Seems like a good idea, no?
I wrote about that. I'm actually against suspending sovereign immunity. There are lawsuits that can be brought against actors who are not the government. I always think that it's much better to handle government-to-government stuff at a diplomatic level, which doesn't preclude, in fact, I think would encourage the possibility of having a settlement fund for Americans. But what my hesitation with this always is that the United States government and its officials are the most active government in the world, and we have a lot to lose if sovereign immunity gets degraded. And I think we always have to remember that when we think about these kinds of provisions, which always sound popular when they get proposed, but I fear we have more to lose from them than even China does.
I'm not sure that the deepest pocket wants to justify reaching into pockets, and that's essentially what this would amount to.
Rick, it looks like it's just us. Chris, where are you?
I don't know where he went.
I'm here, gentlemen. Sorry about that. Wisconsin internet. I don't know. Thanks for the answer. And actually, it's a good time to conclude. So I'll let you both, if you have any concluding thoughts, before I make a few housekeeping notes.
I'll just say it was a pleasure to do this, and I must say, I think I learned more at this than I have in any other one that we've done before, and I want to just compliment Rick on a great job. It was really informative.
Yeah, and I want to echo that. I always enjoy Andy's legal analysis. I always enjoy doing events with National Review. I think I've been a subscriber to National Review for longer than Chris has been alive. And, it's always great to do an event like this. It'll be interesting to see what happens going forward. We're in a situation where we now have to learn to live with this virus, I think, for a while, and that's going to require a certain amount of prudence. It's going to require a certain amount of ability to make difficult choices, and I think it's also going to require us to stop assuming that everyone else is acting in good faith. I mean, it's going to stress and run in against the grain of what our political discourse has been over the past couple of years, and I think it'll be interesting to see how we respond to that.
Thank you, gentlemen, both for your time. Thank you, everyone on the call, for joining us. I want to just quickly promote both of our organizations. You can follow Rick and his office's work at will-law.org, will-law.org. And let me also apologize for incorrectly saying at the beginning that they were founded in 1991. It was 2011, so quick correction there. And you can follow National Review Institute and our work at nrinstitute.org. We have several virtual panels coming up in the coming days and weeks, so please follow along. Again, Andy, Rick, thank you for your time. Thank you, everyone, for joining us and your insightful questions. We'll see you soon.
Thanks.
Thank you.